Hello students, welcome back to the part 2 of a video class on banker and customer relationship. So last time we have discussed that to find out the criminal, to investigate, the banker is bound to disclose the information to the investigating authorities. We have taken an example of uh, Sushant Singh's Sushant Singh Rajput's murder supposed to be investigated by CBI. So let's go ahead. Consequences of wrong disclosure. Suppose the bank gives wrong information. So what is the consequences? Liability to the customer. Banker should compensate the loss due to the wrong disclosure. So banker is liable if it discloses wrongly to the authority. Liability to the third party. Banker should compensate the loss for the wrong disclosure. Again, liability to the customer if customer suffers loss, and liability to the third party if the third party suffers a loss because of wrong disclosure by the bank. This is Mark Twain has given this particular has said about the banker, and I quote, "A banker is a fellow who lends you his umbrella when the sun is shining." That means it lends the umbrella when there is no need, but wants it back the moment it begins to rain. That means banker asks you the money when you are in trouble and you cannot pay back to the bank. So sometimes this situation may arise in somebody's life when they take loan from the bank. Rights of a banker. Right of lien. Lien is a right of the person who can retain the goods of another in his possession until a debt due to him is paid. Particular lien on particular property. General lien, any property can be retained. Particular lien on a particular property. Now, for example, it depends on a special property. So, for example, land and building. Specified land and building. That is called as right to lien on a particular lien or a particular lien. Next, the general lien. Any property can be retained. So generally, in the sense, whatever belongs to me will be retained by the banker if I don't pay the dues. Banker's right to lien. This is how it works. Okay. Conditions to be satisfied in lien. Banker must possess the property or the security. So the security has to be handed over to the banker first. Then property or security must be in the name of the customer alone, the person who has taken the loan. The possession obtained by the banker must be legally. Legal in the sense there must be an agreement between the customer and the banker. Then only the banker can take action on the lien. Exceptions to the right of lien. Valuable accepted for safe custody. Now, for example, if suppose I have a locker and in my locker there are certain valuables kept by me. Now that cannot be taken by the bank as lien. Banker cannot tell me that whatever is there in the locker will be seized if you don't pay my dues. That cannot be done. This is an exception. Bill of exchange, other documents deposited for other purposes. So whatever bill of exchanges and other documents are deposited for some other purpose cannot be used as a lien against the payment of loan. For example, banker cannot seize my FD account for payment of money. Next, money deposited for special purposes like purchase of securities. Now, any money which is deposited for some other purpose and kept in the bank with certain instructions to the banker cannot use that particular money as a lien. Next, documents available left with the banker by mistake. For example, if I went to the bank and visited the manager with my original documents, so for example, property documents, sale deed, gift deed, whatever, or the insurance papers, insurance agreement, life insurance, whatever, and I went there, I had a discussion with the manager, and by mistake, my file got. I left that file by mistake and I failed to carry it. But I already have a loan with a particular bank. Now, the manager cannot take charge of that particular document file, and it cannot call me and say that, see, your documents are with me now. I will take them as a lien, and until and unless you pay my dues, those documents will not be written by us. Now, this cannot be done by the banker because it's illegal. Next, trust account operated by the customer against his personal account cannot be used as a lien. Security is lodged with the banker for getting a loan before sanctioning such loan. So, before sanctioning the loan, the documents which are lodged or securities which are lodged with the banker cannot be used as a lien for some other purpose. Next, right of set off. I will give an example of this. Suppose I have a gift deed with two properties mentioned in that, and if I have taken a loan on only first property and the second property is without any loan or without any charge. Now, if I don't pay, if I fail to pay the amount, banker cannot seize the other property which is mentioned in the gift deed, which does not have any charge of the bank on it. It cannot be used as a lien by the bank. Okay. Right of set off. This is another right of a bank to set off. Banker can exercise this right by setting off a debt balance in one account with the credit balance in another account maintained by the same customer. For example, if I have two accounts, one account is at default, the banker can use the other account and set off the loan. Right of set off subject to the following conditions. No agreement contrary to this must be there. Now, for example, I must have not instructed the bank not to use that particular money for setting off my loan. Next, this formal notice to the customer has to be there. See, without giving notice to the customer, the banker cannot take any action. Capacity of the customer must be same in all the accounts. So, next is different branches of bank will constitute one entity. In this case, banker has the option. Customer can't compel the banker. Banker can do this even after the receipt of garnishee order. So this is the condition of. Now let us go to the next, right of appropriation. Appropriation of amount will arise when a customer owes several debts to a banker and his payment is not sufficient to discharge all the debts. So appropriation of amount can also be done by the banker if he has multiple loans. Next, right of charge interest, incidental charges, etc. Banker has the right to charge interest on due from customers. It has the right to charge incidental charges on customers' account. So, if there is a good relationship between the customer and the bankers will give the customer certain benefits, certain concessions, certain good offer. In this case, the banker is offering higher interest on the FD, fixed deposit of the customer, because of the relationship, good relationship with the bank. Rule in Clayton's case. Bank's right of appropriation. Question of appropriation arises when a customer owing to two or more debts to the banker pays in money which is not sufficient to discharge all the debts. So money will be appropriated to the loan which requires more money to be paid, and the lesser loan will be kept without an appropriation. This is called as banker's right to appropriation. Rule in Clayton's case. Where the account goes into debt, the first item on the debt side is cancelled by the first item on the credit side. That is, appropriation takes place in the order of time. Where the account goes into credit, the first item on the credit side is extinguished by the first item on the debit side, and so on. In other words, appropriation takes place in chronological order. Facts of Clayton case. There was a partnership firm running with the banking business by name Devaynes, Daves, Noble and Company. Devaynes, Daves, Noble and Company. It had four partners: Devaynes, Daves, Noble, Craft, and Barbock. Mr. Nathaniel, Nathaniel Clayton was a chief credit of the firm who was having current deposit account. Later, Devaynes, the chief partner of the firm, died, and the surviving partners continued the business under the old name, despite written notice from Devaynes' son and from the trustees of the father that the continued use of the name was without their consent. Nathaniel Clayton, represented the surviving partners, continued to deal with the partners both by paying in and drawing out, some withdrawals being made after the death of the partner. In the case of Clayton himself, the balance of £1,713 at the death of the partner was reduced within a few days to £453. No payments in being made in that time, and before the bankruptcy, withdrawals amounted to considerably more than the whole sum of £1,713. Clayton claimed his money from the estate of the deceased partner. His claim was that the amount existed at the time of death of the baby, and that which was existed at the time of insolvency was the same. Therefore, the deceased partner's estate was also liable. He withdrew the amount after the death of the baby and so only from the money deposited by him after the death of the partner. The firm was solvent at the time of the death of the partner, for which the legal representative of the deceased partner also made liable on the basis of unlimited liability of the firm. That is, all debts may also be received from any partner, including the legal representative. His arguments were not accepted by the court, and accordingly his claim was rejected. In this first item, it is the first item on the debit side of the account that is discharged or reduced by the first item on the credit side. Hence, it was held that Devaynes' estate was not liable. Therefore, the credit entries in the account adjust or set off the debt entries in chronological order. Conditions for the application of the rule in Clayton's case: the account should run still. If the account is broken and a new separate account is opened, this rule does not apply to the old account. There should be no other agreement contrary to it between the debtor and the creditor. Example of rule in Clayton's case: X, Y, and Z are partners in the firm, which is enjoying cash credit limit of ₹10,000. A dies when the account shows a debit balance of ₹8,500. This account is allowed to continue undisturbed even after the bank has been informed of X that as Y and Z decided to run the business in it. Subsequently, there have been credits of ₹3,500, ₹5,000, and debits of ₹4,000 and ₹6,000 on different dates. Though the present debit balance is ₹10,000, X heirs are no longer liable for this debt. This is for the reason that the debit balance of ₹8,500 at the time of X debt is completely wiped off by subsequent credit entries of ₹3,500 and ₹5,000 as the account was continued unbroken. The loan raised after X debt is the sole liability of the surrounding partners, namely Y and Z. On the death of the partner, the account of the firm should be broken to avoid the operation of the rule in Clayton's case, so as to make his estate liable for the debts created before his death. Customer's duties to obligation to his banker: to pay the overdrawings. This has been reduced by the introduction of the credit card facilities. To pay bankers' charges for the services rendered by the bank, for example, offer, DD, travel checks, etc. Operation of account: customers should notify the banker if any person has forged his signature to withdraw money. If he fails to do so, the bank will not be held liable. Next, due to reasonable care in drawing checks, the customer needs to draw checks on his account in a way which does not facilitate the alteration of the amount. Failure to do so, this entitles the bank to debit his account accordingly. Not drawing a check in insufficient of funds: the customer should not draw a check for insufficiency of funds in the account, which leads to dishonour of the check. Termination of relationship or closing an account: the relationship may be terminated by the parties voluntarily and by operation of law. Termination by the customer: if the customer is not satisfied with the services of the banker, he can terminate the relationship. If he cannot get the facilities from the banker, he can terminate the relationship. If he loses his confidence in the bank's reputation, economic stability, etc., if he does not agree with the terms of the bank, so termination by the customer by himself. Termination by the banker. How banker can terminate the customer. Under the operation of law, death of the customer. As soon as the banker receives reliable information about the death of the customer, he should stop the transaction of the account. Next, customer's insanity. In case the same person becomes lunatic or insane after opening the account, banker should stop the transaction. Customer's insolvency. Immediately after knowing that the insolvency petition is filed against the customer through reliable sources, the banker should stop the transaction of his account. Order of the court. Sometimes courts issue garnishing order and order under Civil Procedure Code and Specific Relief Act against the customer in certain circumstances. The banker has to oblige the orders of court assignment. If a customer assigns his account with its funds to any other person and gives the assignment order to the banker should hand over the funds of the account to the assignee and should close the customer's account. Winding up of the company. If the company is wound up, the banker should act according to the instruction of the court. Closing of the partnership firm. If the partnership firm is closed by the consent of the parties or due to death of one or more parties, the bank should stop the transaction. Customer of an enemy country. During war period, if the customer belongs to enemy country, the bank will justify in closing the account. Closing an unsatisfactory account by giving notice. Sometimes the customer becomes a nuisance through constant failure to honor an overdraft agreement or through drawing checks without providing funds for meeting them or issuing post-dated checks. At that time, the bank can close the account. So thank you students for patient hearing and thank you for watching this video. I hope you have understood so many things. If you have any difficulties, please feel free to ask on your WhatsApp group and uh, yeah, we will discuss on that particular issue. Thank you so much.